This podcast is brought to you by the School of Advanced Study, University of London.
Dr. Slynn, I'm very grateful to be invited to speak, of course, today, but I really ought to say that I ought not to be here. This is a rubric of the application of English law after independence, but Hong Kong, although it was a British colony for over 150 years, is not and has not become an independent state. Since 1997, as you know, it's been a special administrative region of the People's Republic of China, and it's governed by a constitution enacted by the Chinese People's Congress, and a constitution that expires in 2047. And under this constitution, the basic law, Hong Kong, of course, now has a high degree of autonomy, as it said. Not total autonomy, and still less does it have the powers of self-government that former colonies now enjoy. However, most of its pre-existing laws, including the common law, continue in force in one form or another. And the courts and the judiciary, by this Chinese constitution, are specifically required to continue to administer justice in the same way as before, with guarantees of judicial independence and security of tenure. So if you were to wander into a Hong Kong court today, you'd hardly notice any difference from the courts of the old Crown colony. More Chinese Hong Kong-born judges and barristers, some of course still English, still dressed in wigs and gowns, piles of law reports, and still using the same old mummery language, "May it please your lordship, if your lordship pleases," and that wonderful phrase, "Would this be a convenient time?" which is the lawyer's equivalent for "it's time for lunch." In the criminal courts, you might see a jury at work, and you'd see the same heavy emphasis on the burden of proof and rules of evidence. You might come across some simple cases that are conducted in Cantonese, the vernacular dialect, and you'd think that would be a welcome change from the old days. What might surprise you is to find that in the old French mission chapel, there sits a totally new court called the Court of Final Appeal, CFA. And this came about, of course, because the role of the Privy Council ended abruptly in 1997, and the Chinese couldn't pretend to have a suitable alternative in Beijing to replace it. So a new third-tier court was set up in Hong Kong, and its unique feature is that judges from other common law countries are permitted to sit in it. So you might spot Lord Hoffman from London, or Lord Phillips, or Sir Anthony Mason or Murray Gleeson from Australia doing a stint of duty. And you might think that is a remarkable concession by a Chinese sovereign state to allow foreigners to come in and settle questions of law in their highest court on Chinese soil. So you might conclude that nothing much has changed and nothing for the worse, and that would be broadly true for the run-of-the-mill cases, the private commercial law cases. But the most significant changes have come about in the field of public law, with the basic law, the Constitution, presenting new challenges. First, the Constitution bars the courts from exercising jurisdiction over, and the phrase is, acts of state such as foreign affairs and defense. Now, what is or is not a matter of foreign affairs came up recently. A private party wanted to enforce an arbitration award against assets in Hong Kong that belonged to the Democratic Republic of Congo, who'd been found liable for large commercial debts. The Congo, having no meritorious defense, chose to plead sovereign immunity, which it said was a matter of foreign affairs, over which the courts had no jurisdiction. It pointed out that Chinese law confers absolute immunity upon states in Chinese courts. But the claimants pointed out that the common law was applicable in Hong Kong under the Constitution, and under that common law, a sovereign has no immunity in respect of trading or commercial activities. But after a great deal of judicial disagreement and head-scratching, Congo's plea finally succeeded. It was a matter of foreign affairs, and so the award was not enforced. Second general point I'd like to make is that Hong Kong lawyers now have to keep up to speed with common law developments, not just in England, but in the many other countries around the world in which it's taken root. As a new superior court, free of any past shackles, the Court of Final Appeal says it's not bound by any previous decisions, not even its own. The court has encouraged citations of decisions from all common law jurisdictions, because, as the Chief Justice declared, at the end of the day, the courts in Hong Kong must decide for themselves what is appropriate for our own jurisdiction. So Hong Kong's common law now takes inspiration from many overseas sources. Of course, with judges from the Supreme Court in England, High Court of Australia, and Supreme Court of New Zealand sitting in the CFA, it's not surprising those sources have considerable influence. But the open door is wider still. Canadian jurisprudence, on human rights particularly, has been very influential too. The third general point is that the most important challenge of all comes whenever the detailed constitutional provisions guaranteeing fundamental human rights are invoked. Now, this was never a problem for colonial judges because the UK, of course, notoriously managed to get along without any written constitution. And the old letters patent and the royal instructions we had in the colonial days had really little to say to the man in the street. So here presented a new learning curve. And the first question for the courts was how to interpret this new constitution, this new Chinese constitution, which binds Hong Kong. Now, a language of a constitution, I think Lord Judge said this morning, it often has high-flown phrases. It distributes powers, and it sets out political aims, and it sets out purposes. It is bound to contain broad-brush statements of principle, not condescending to precision, not matching the standards of a parliamentary draftsman. So uncertainties and gaps and ambiguities are inevitable. And the fact that the basic law is actually rendered in both Chinese and English texts only adds to the problems of definition. And early on, the court laid down how it should be interpreted. Language must be purposefully construed, generously construed. The approach should not be literal, and there should be a general presumption in favor of no change from the previous colonial days. There is some unease because the basic law of this constitution expressly gives the ultimate power of interpreting or amending the basic law to a Chinese political assembly, the National People's Congress. Now, that doesn't preclude the Hong Kong courts, of course, from interpreting it whenever it's cited in legal argument, but if the issue touches upon Chinese responsibilities, foreign affairs, the development of the political system, and so on, the court has to refer it to the National People's Congress and is then bound to apply its ruling, though it may also choose at the same time to express its own opinion on the interpretation, as it did in that Congo case. In an early case that gave rise to much debate, the Court of Final Appeal held that certain applicants were entitled to a right of abode in Hong Kong under the basic law. The Hong Kong government was aghast because there were hundreds of thousands in China who might claim the very same right to live in Hong Kong. But because this right was constitutional, the Hong Kong government could do nothing to reverse the judgment, as it could have done if it had been legislation. They could have passed amending legislation to change the law. So it requested the Chinese Political Assembly, the NPC, to reinterpret that provision, it having the ultimate power of interpretation. And of course it got the answer that it wanted. This, of course, did not affect the rights of the particular parties who had been successful in the case, but it deprived all future claimants of relying upon the court's ruling. And this tension between the rulings of the courts and how it might be interpreted by the political body has obviously caused some unease. Next point, how to apply this constitution. I've mentioned the rights and freedoms enjoyed by the Hong Kong residents are set out in full in this basic law. In a whole host of cases, it's been argued that a provision of Hong Kong statute law, its legislation, is incompatible with a constitutional right. Now, the court early on ruled that any court, and note the word any judge, is duty-bound to strike down a legislative provision that is inconsistent with the provisions of the basic law. Now, as you know, because of the way in which many of these rights are framed in qualified terms, as in the European Convention, judges had to learn how to balance an individual's right or freedom against a public need for constraint. And in striking that balance, the court has certainly favoured the individual because it requires the administration to demonstrate that any justification it puts up to justify a constraint is first necessary, secondly rationally connected with the purpose, and thirdly proportionate, a three-part test. And though account is taken of the views of the legislature when they passed the legislation, I'm afraid they rarely carry the day if the judges think that the purpose is not justified. Let me give just two examples. Laws banning every prisoner from voting or being entered upon the electoral register were all struck down by a High Court judge because they irrationally denied the constitutional right of every permanent resident to vote. And on the other hand, the Court of Final Appeal upheld convictions for burning the Chinese national flag in a political demonstration. It was said that for the sake of public order, it was a necessary and proportionate restriction to impose upon freedom of expression. So let me just go on to conclude with time running out, because I feel as if I'm the last batsman come in to score some quick runs before the captain declares the inning closed. Let me just say that the courts have also had the whole question of how to deal with the consequent problems of striking down legislation. For example, there's the black hole problem, the one that was memorably arose in Manitoba, you may remember, when a court decided that 4,000 statutes going back over 90 years were unconstitutional because they'd been not enacted in 2 languages. So after holding that all prisoners should not be denied a vote, or in another case that the practice of telephone interception had no proper legal basis, the judges recognized that the administration needed time to plug the gap, to permit elections to be properly held on a proper electoral register in the one case, and to avoid interrupting investigation of crime on the other. So drawing on common law precedents, the court decided as a matter of discretion that the effect of a declaration of invalidity could be suspended for a period reasonably required by the administration to review its policy and to enact further legislation. And I should have mentioned other techniques that have been developed, reading down a statutory provision, or sometimes even taking out words to try and preserve the effect of legislation. In the case, for example, where the insider dealing tribunal had acted as if they were a civil proceeding in terms of receiving evidence and the like. But in fact, they had powers to punish people by imposing financial penalties. And this was said to be contrary, but the way they'd conducted the case, contrary to the guarantees given for people who were prosecuted in a court with punitive powers. It's the answer, said the judges, was, well, we'll just leave out that bit about the power to fine, we'll strike that bit out, and so we'll preserve it as if it had always been a civil proceeding. Now, I just want to finish then on a high note. There is still recognition in Hong Kong, although there are a lot of political problems at the moment, problems over governance, problems over the pressures of various people to press for faster development towards democracy, threats of civil disobedience, actually this summer. But there's still recognition that of all the various governmental institutions that have been created since 1997, the courts, in administering justice and maintaining the rule of law, have come through the transition best of all. Constitutional change has been absorbed. The common law has been enriched with the aid of the foreign judges and drawing from sources all over the world, and the bench has become much stronger by recruiting the cream of the local bar. But above all, and this is perhaps my final point, it is my final point, it's the flexibility of the common law itself, its pragmatism, its adaptability, and its capacity for innovation that has enabled the judiciary to rise successfully to the challenges of our new legal order. Thank you very much.